And welcome back to Talk Back Now, the one-hour edition on Monday, brought to you by the Mustard Seed Asian Cafe at Southgate Mall, Kootenai Creek Village, the maintenance-free active adult community in Stevensville with the best of Western Montana living. Call 777-5387. Dig It Excavating, bringing 30 years of excellence to every job. For all your excavation needs, call Glenn, 214-4292. Also brought to you by Transport Equipment, your headquarters for RV service maintenance and repair, 541-9097. All right, one of the most anticipated days of the month here on Talkback is when we get to visit with Rob Natelson from the Independence Institute in Denver, Colorado. Good morning, Rob.
Good morning. I assume by what you mean of one of the most anticipated days is that this would be the 29th leading anticipated day in the month, right?
No, it's always a good time to have Rob Natelson on because I know we're going to get a lot of good stuff. So you and I were just comparing notes a little bit. I finally got a little bit of culture and went to Great Britain to see my daughter. So we spent a lot of time in London and also in Scotland. And so I'm just beginning to get a tiny sliver of the flavor that you've been telling me about all these years, of all the research and time that you spent over in Great Britain.
Well, it's certainly a place I recommend Americans visit. I mean, it is more than any other country, the country that represents our roots. And if you haven't been abroad before, it's probably the easiest country to visit because the language at least approximates our own.
Well, it all depends on...
But the other thing is that the British are very friendly.
Yeah, it all depends on who's waiting on you. For many of those folks, English is not even a third language, but... Anyway, but aside from that, we had a marvelous time.
Well, you do after a while develop an ear for the different accents. For example, here in Lakewood, Colorado, I was in a store yesterday, and a young man waited on me, and he was clearly English, and I could tell he was from the southern part of the country the way he spoke. So I asked him where he was from, and the answer is he was from Sussex, which is on the south coast. So after you've been there for a while, you pick up the different regionalisms in the same way that, an American would know so-and-so's from New York or from Montana or from Alabama.
Basically, what I was referring to is the fact that we went to a lot of different restaurants and pubs before we actually met anyone who was British.
Oh, really?
Yes.
That was in London, right?
Yeah, that was in London.
Yeah, London's like New York. Every other person you trip over is from somewhere else.
Yeah, it's a very multicultural city. Yeah.
Yeah, and one of the things that's added to it, or actually two things that have added to it, is one, the free immigration policies of the European Union. So you'll see Slovaks and Poles and Germans and from all over the European Union and London. But added to that is the fact that Britain is the country that leads the Commonwealth of Nations. And so you've got people from Australia and Pakistan and Uganda, everywhere from all over the world.
Yeah, when we would hire an Uber driver, we had 3 Uber drivers. One was from Poland, one was from Albania, and the other one was from Afghanistan.
Yeah.
So
now,
there
what
you go.
Need to do, of course, is to get out of London and see other parts of the country.
Oh, we did.
I gather you spent 3 days in Scotland.
Yeah, we did, and it was absolutely one of the most beautiful places on earth. My daughter couldn't wait to get us up to Scotland because she loves that. So I love it.
It is beautiful. I once described Scotland as Montana with water.
There you go. there are plenty of lochs in Scotland. So.
Well, yes, and of course it's also surrounded by the sea, except on the southern border,
right,
where it borders with England. It's not, but otherwise it's very much a seacoast country, and it's a very rugged coast, and so you're constantly encountering inlets.
Yeah, we did have a chance to see the North Sea a little
Scotland
bit. So.
Is if you go, one interesting thing about Scotland is if you go up to the very northern part, people speak with a Scottish brogue, but they speak with a Scottish brogue with a Norwegian accent. And there's a county up there called Sutherland, which means Southland. And the reason it's called that is because you had mass migration from the Nordic countries into Scotland, which, by their standards was pretty far to the south.
There you go.
So it really is interesting to get that far up. And it is, as you say, very beautiful.
But anyway, that's not the reason we invited you here on the show, is to
how come
talk about our our mutual love of Great Britain and Scotland. We want to talk about what's on your mind this morning. I know that you are very another great honor for you. You have been published again in a prestigious publication. What's that all about?
Well, this was an article on the tax and financial terms in the Constitution. If you pick up the Constitution and you read it, you see words like tax, direct tax, excise, tonnage, duty, impost, and most of us don't really know what those terms mean, but they had very specific terms to the founders. And so in this article, I carry on a project that I've done before and try to explain what those terms mean to the what they meant at the founding, and explain that to the average person today. The Obamacare case that was decided in 2012, that decided that the penalty for not buying individual health insurance was a tax, and furthermore that it was a direct tax, is a good example of how that language is relevant today. And in fact, my article takes apart that particular decision.
So when it comes to taxes, under the original understanding, what's okay? What were the things they were allowed to do, and what sort of things were on the periphery or not allowed?
Okay, well, the American Revolution, as you know, was largely fought over taxation. And in the run-up to the American Revolution, there are a lot of writings by Americans in which they explain what their understanding of a tax is. So there's no real mystery as to what a tax was intended to be. A tax is an imposition by government for revenue, for money rather, where the money goes to the government, and the purpose of the imposition is to raise revenue. So there are different reasons for imposing financial exactions or financial impositions. Sometimes the money simply may be used to finance a regulatory program, or sometimes the money may be a prohibitive tariff where the level is set so high that you want to stop all the imports of a particular good completely. Those aren't taxes. What a tax is an imposition for revenue. The reason this is relevant to the Obamacare case is that evidence, that information apparently was not in front of Justice Roberts when he wrote his opinion, because he held that the Obamacare penalty was a tax, even though it wasn't imposed for the purpose of raising revenue. It did raise a little bit of revenue, but mostly it was imposed to coerce people to buy health insurance.
It was a punishment.
And so that disqualified it as a tax as far as the Constitution is concerned.
Okay, we're up against a break. 721-1290 is our number. Rob Natelson joining us, and we will have more with Rob Natelson from the Independence Institute when we come back. And we're back on Talkback. 721-1290 is our number, 1-800-568-5309. Rob Natelson joining us from Denver, Colorado, from the Independence Institute. Oh, go ahead, John.
Yeah, we were talking about taxes. By the way, if you want a commercial-free experience about Rob Natelson's thoughts on the Constitution, you can also check out his book, The Original Constitution, What It Actually Said and Meant, which is, is in fourth printing now or third?
It's in its third edition. By the way, this new article on that I wrote on the Constitution's tax terms and financial terms is also available on the website. The traditional URL to getting there is constitution.i2i.org. That's constitution. The letter I, the number 2, the letter I.org. They recently messed up the website, but I think that URL will still get you there.
I checked it this morning. It's there. You can find a link to it in our Facebook blog this morning as well.
Good.
So, yeah, the hyperlink is still working there, Rob.
Now, I will warn you, the article was written in a scholarly journal, so it's a little wonky, but I think most people can comfortably read it, and it does explain what all those terms in the Constitution, like tax and excise and impost, actually mean.
So I guess one of the questions I had is you were talking about how the framers just got done with a war, right? Taxes were a big deal. It seems to me that they left a lot of room for taxation. or at least that appears to be the case now, that I would have thought they would have sewn the door shut a little bit tighter.
That is interesting. In fact, one of the criticisms of the Constitution when it was being debated was that it opened the door too much to taxation. The taxation clause is one of the broadest clauses, and it seems to give the federal government almost unlimited power in that area. There are a few things the government can't do. For example, it can't impose taxes on exports. It can tax imports, and the power is limited to true taxes. The Obamacare penalty is not a true tax. It's an attempt to regulate personal behavior, and therefore outside the enumerated powers. But you're right, the taxation power that the federal government was granted was pretty broad, and much of the Federalist Papers, for example, is devoted to defending that against criticisms from opponents of the Constitution.
So it's my understanding that the big difference between their interpretation and our interpretation of taxes today is this idea of direct taxes and the sort of things that the general welfare, what that means as far as what you can spend the taxed money on.
Well, there's two different issues. General welfare, and we've discussed this before on this program, means that the money has to be stored up for purposes that serve the general interest as opposed to the interest of particular localities or particular special interest groups.
So if I want to build a yarn museum in Missoula because of our strong history of yarn, that's not something I could get tax money for?
Well, today you can get it for anything because the Supreme Court essentially wrote the General Welfare Clause, which was originally a restriction, out of the Constitution. I mean, it did that in the 1930s. And so right now Congress can spend anything it wants to on anything and has become a huge auction house as a result. Because the Supreme Court no longer enforces the restrictions on congressional spending, we now have a, $18 trillion debt. I mean, that's fundamentally the reason for it.
Now, Rob, with the death of Antonin Scalia, there was a Supreme Court ruling that came down, I believe, a week or so ago. That was, I believe, a tie.
The unions?
Yep, over the unions, 4-4, that actually gave the unions a victory. Now, I don't know if you can, look into your crystal ball and predict what the late Justice Scalia would have voted on that particular, how it would have come down on that particular subject. Do you have any idea?
Most people who follow the court think that Justice Scalia would have sided against the union to extend the free speech rights of union members to include the right not to join a union and not to pay an agency fee. So that's a good example of how the Supreme Court has real consequences, and it's something that people need to keep in mind when they weigh their options for the presidential election. By the way, you also raised the question of direct taxes. This was one of the most interesting parts of my article, at least one of the most interesting part of the research that I did. There's a widespread belief out there, which Justice Roberts reflected in his opinion, that really nobody knows what the term direct taxes in the Constitution means, other than it means head taxes and real property taxes. And what I found was that the founders absolutely knew what direct taxes meant, and that direct taxes covered a wide array of affairs, a wide array of levies, and that even if the Obamacare penalty was a tax, then it was a direct tax, and it was unconstitutional because it was not divided up among the states by population. So that was an interesting finding because as I said, there's been this widespread mythology in modern America that the term direct tax was a very narrow one that nobody really knew what it meant.
So why does some lawyer from the Intermountain West have access to this information that the Supreme Court doesn't have access to? I mean, how did you find this definition of direct taxation?
Well, it's really interesting. During the Obamacare litigation, we at the Independence Institute had to decide whether we wanted to involve ourselves in a case by filing a friend of the court briefs. And we eventually filed a friend of the court brief on the Medicaid extension issue, and we also filed a friend of the court brief on the Necessary and Proper Clause issue, and we won on both of those issues. And if you read Justice Roberts' opinion, there are definite traces our briefs on both those issues, because we chose those because other parties did not address them adequately. But nobody took the tax issue seriously. The federal government took the position that the Obamacare penalty was a tax, but everybody assumed, including, I think, the government, that was just an extreme backup position that had no real chance of prevailing. The general attitude was, of course it's not a tax. And so neither we nor very many other people submitted information to the court on the tax issue. If you read Justice Roberts' opinion, and lay people have noticed this. In fact, I think one person, it might have been Alan, pointed it out on this very program, that when you read Justice Roberts' opinion and you read his discussion of the Commerce Clause, the Necessary and Proper Clause, of the Medicaid extension, the opinion is very strong, very confident, and when it gets to the tax issue, it suddenly suffers from a dearth of information. And I think that was the problem. Let me just say that sometime after the opinion, I was on a panel, and a member of the panel sitting right to my left was Paul Clement, who was the lawyer who argued the case against Obamacare before the Supreme Court. And somebody asked whether the court's decision on taxation was correct, and I explained to the audience in detail why the Obamacare penalty was not a tax. And if you look at a YouTube of that presentation, you can see Paul Clement looking very uncomfortable because he did not have that information.
Wow.
when he was litigating the case. Wow. Now he is a top Supreme Court litigator. There are none better, but nobody apparently had done adequate research, which is one of the things that got me to do the article.
Yeah, we're going to come right back. I'm sure it's a very uncomfortable moment, especially the time has come and gone. Wish I could go back and redo it. But anyway, we're going to come right back. We have lines open if you would like to visit with Rob.
Yeah, I was going to say, for Mike and Catherine, the people that called in earlier, you're welcome to call in. We're opening up the floodgates. Right. 721-1290 is the number.
Lines are open, and we'll be right back. This is Talk Back, and our guest on the phone, Rob Natelson from the Independence Institute.
And we just found out that it's Rob's 35th wedding anniversary, so congratulations. And he's working right now. You're not married to your work, are you, Rob?
No, I'm married to my wife, Betty.
Well, congratulations.
Thank you.
That's wonderful news. All right, Catherine's on the line. Good morning, Catherine. You're on Talk Back. Hi.
Hi, Catherine.
Good morning. There's an interesting court case coming out of Colorado that is being appealed to the Supreme Court. And in fact, I think the Supreme Court is hearing it this week. And it has to do with racial bias versus privacy of jury deliberations. So my questions are, why are jury deliberations constitutionally protected? And if they are or if they are not, how would that, or if the Supreme Court rules that they are not, how would that affect current and former cases where you have people who then would be able to allege that they need to open up jury deliberations to public purview?
Well, Catherine, I haven't. I see that you haven't diminished in any way your customary ability to throw curveballs.
Sorry.
You are truly a most valuable player. You should get the Cy Young Award.
Okay.
Traditionally, jury deliberations have been protected, and I've not researched the area specifically, but generally speaking, the Constitution protects those incidents of the jury, in other words, those aspects of the jury that were in place at the time of the founding era. That's why, for example, a federal jury has to be composed of 12 people, as opposed to state juries that don't have to have that many. And generally, the secrecy of deliberations was part of that. So, yeah, it's protected. Is it protected? Absolutely. Probably not. And are there is this a sufficient circumstance to unshield those deliberations? I don't know. We'll see what the court says. And what are the possibilities for opening up cases later? Well, significant. I mean, I can see somebody who was convicted by a jury, someone who's a member of a racial group that he claims the jury was biased against, and claiming years after the conviction, that his conviction should be set aside because the jury is racially biased. So I think the court's probably going to consider long and hard before they agree to the opening up of jury deliberations, because I'm not sure the court wants to deal with the flood of litigation that
Rob,
could potentially result.
Let me jump in for just a second here. We just had a trial in Helena with Art Whittick, who was charged by the Commissioner of Political Practices, Jonathan Modell, with accepting money from a dark money group, and the jury came back 10-2 and convicting him on all charges. Now, is it possible, because the attorney and Mr. Whittick are claiming there was bias because the fact that he is a conservative and has been very vocal in his conservative views and his opposition to the placement of Mr. Modell in that office, and he was viewing it more as a personal battle. So is that something that could go to bias in what Catherine is talking about? Now, there wouldn't be racial, it would be political.
All right, political bias generally is not considered subject to the same sorts of rules that racial bias and so forth are. There is a provision, however, in the Montana Constitution that protects against political bias. Whether it would apply here or not, I don't know.
Okay.
My educated guess is that if Mr. Modell, even if it were demonstrated that Mr. Modell brought the prosecution because of political bias, that probably would not be enough to set aside the verdict. If it could be established that the jury was corrupted by political bias, that might be a different situation. But I would recommend that if you want to explore that, you get a criminal law expert on your show and pose those questions to him or her.
Now, Catherine, did you have another question?
No.
Okay.
I was just curious about it because I read about it in the San Francisco Gate, which is a newspaper website. And since it's coming up, and since I can foresee a whole huge number of ramifications from either way, I was just curious what Mr. Natelson thought.
Okay. So. Thank you, Catherine. Appreciate your call. We're up against a break. And Gregan, we're going to get your call on in a moment. We have one line open at 721-1290. Our guest on the phone, Rob Natelson from the Independence Institute. Hey, thanks for joining us on Talkback. We spend an hour talking with Rob Natelson once a month, and we are absolutely thrilled to have him on the line. Rob joining us from the Independence Institute. We have all three lines humming here, Rob, so let's get right back to it. Gregan, you're on with Rob Natelson. Good morning.
Good morning, gentlemen.
Good morning.
A question I have is that as a argument runs from steps from court to court and arrives at the Supreme Court makes a determination constitutionally or by the amendments. Why can a judgment by the Supreme Court be changed depending on the political wind? Now, for instance, we have the Second Amendment. It is explicit in the list of amendments, but yet when it gets to the Supreme Court, it can be changed depending on how the new Supreme Court justices decide they wish to revisit that. And thank you very much.
Okay. So is it possible for the winds of political change to change the Constitution, Rob?
Well, here's the situation. The court doesn't have the power actually to change the Constitution, but it does have the power to interpret the Constitution. And legal interpretation is not an exact art. It's not an exact science. Let me see if I can communicate it this way. When there are a whole range of legal questions where if you ask 15 lawyers, they will all give you the same answer, okay? 15 competent lawyers will all give you the same answer to many legal questions, probably most questions. But legal questions, like other questions, are sometimes tougher. And the tougher and tougher the questions get, the less consensus there's going to be among interpreters. As a general rule, the Supreme Court gets the toughest questions. These are the questions where the lower courts have split. Now, the caller mentioned the Second Amendment, and that's actually a good example because, and I'm speaking now as somebody who's a constitutional historian, the evidence on the meaning of the Second Amendment is not as clear as it is on some other amendments. Now, I think that the court was right to decide that the Second Amendment grants an individual right, but there wasn't a whole lot of discussion about the Second Amendment at the time the Constitution was debated, and so that we don't have a whole lot of information to go on. In those circumstances, it's easy to understand why the court would split, as it did in the Heller case, in which it ruled that the Second Amendment does grant an individual right, why it would split 5-4. Fortunately, the vast majority of cases are not that difficult. Now, there are also times of extreme stress where questions that should be relatively easy for the court aren't relatively easy because of the stress. And a great example was during the Great Depression when the court stopped applying the limits on Congress's commerce power and Congress's spending power. Those should have been easy. I mean, the court should have declared various programs unconstitutional that it validated. But the court's judgment was influenced by extreme pressures and extreme stress. And I'm not talking about the so-called court packing plan. I'm talking about other developments. So to summarize here, legal interpretation is not an exact art. On the majority of legal questions, lawyers and judges are going to be unanimous, and that's even true of a large number of cases that get to the Supreme Court. But the Supreme Court deals with the very toughest cases, and often interpretation is very difficult, and so you get split decisions, and then you also get cases of political stress. Fortunately, those are a small minority that tend to influence the court as well.
All right, we got a question from Elena on Facebook. She says, while doing his tax research, did Rob read The Law That Never Was by Benson Beckman and the Federal Mafia? Benson Beckman and the Federal Mafia. Erwin Schiff, I believe, is the author. By the way, the 16th Amendment states, among the several states, not among the several people. So did it not give the feds the power to directly tax the people via an income tax? Yes or no?
Okay. First, regarding Elena's question, no, I didn't read that. I was looking only at founding era material. And I tried, when I do this, not to look at a lot of stuff from later because I don't want to be biased in doing the historical research. If I'm reading something that was written in 1960 or 1940 or whatever, it will sometimes bias the way I look at the historical record, and I carry enough modern biases with me. Regarding the 16th Amendment, the Constitution says that direct taxes, and this would include income taxes, that direct taxes have to be divided up among the states, apportioned among the states, so that states pay, or people within the state, pay according to the population of their state. So, for example, if Montana is twice as populous as Wyoming, Montana has to pay twice as much in direct tax than Wyoming does, even if Montanans are poorer or richer. That's the apportionment requirement. The 16th Amendment, all the 16th Amendment did was to say it's no longer necessary to apportion among the states with respect to income taxes. The 16th Amendment didn't give Congress the power to impose an income tax. The Congress already had that power. But there was no need after the 16th Amendment to divide up the revenues among the states according to population. So that's all the 16th Amendment did.
Okay, we're going to come right back. Ron, we'll get your call on. We also have a line open. If you have a question for Rob Natelson, our constitutional scholar from the Independence Institute, we have a line open for you. You can make your comment, as Elena did, on our Facebook page. We'll be right back. Thanks for joining us on Talkback on this Monday, April the 4th, 2016. Rob Natelson joining us from the Independence Institute in Denver, Colorado. We have another phone call. Ron, thank you for holding. You're on with Rob Natelson. Hi.
Hi, Rob.
Hi, Ron.
I've got a question about how these things kind of creep, like, the tax on insurance from Obamacare, etc. We've also got this requirement to keep insurance on our vehicles. That's demanded, otherwise we can't even drive. No, I just had the first accident I've ever had in my life. I'm 70 years old. Wasn't driving carelessly or anything on these country roads. Just you're being careless even getting on them with all the elk and deer and cows and everything else, you know. And but anyway, yeah, the state trooper gave me. He tried like hell to get me for DUI, but he couldn't do that. And I told him I'd never had an accident in my 70 years of driving or 50 years of driving. And he must have looked in his computer for an hour to find something, but he couldn't. So he ended up giving me a ticket for careless driving, which I've never heard of before. You know, reckless driving, yeah, but careless driving is such a vague term. It applies to anything and anybody, so the state can nail somebody for $85, right? But the other thing on this is that I'm low income. When that hits my insurance company, my rates are apt to go up so far that I'm not even going to be able to afford to drive.
So can you bring it back to the Constitution somehow?
Well, yeah. How is it that you know, we're required to have this insurance, just like Obamacare.
Sure.
And so why is it then creeping out, say, at the state level to these vague terminologies that you either pay or you can't drive?
Okay, well, let's let Rob answer that. Thanks for the call.
Okay, Ron, are you gonna contest that ticket?
Oh, I'm sorry. I let him go. I apologize.
Peter dropped Ron.
Well, I mean that.
I would contest it.
That might, yeah, I think he ought to contest it. I mean, even if he's technically guilty, and I don't know what the elements of the offense are, or what his facts are, but even if he's technically guilty, he goes before the judge and says, "Look, I'm 70 years old. It's the first accident I've ever had. The situation's bad enough because probably the insurance company is going to raise my rate because of the accident." Most judges in that circumstance are going to be pretty reasonable. He may dismiss it outright. He may reduce it to something less significant. States have imposed insurance mandates for many, many years. Most states require you to have insurance of some kind if you want to drive. The power of the state to do that is unquestioned, and that's because the state has a general governmental power, which lawyers call the police power, means the power over policy, really, and the states can do that. What was striking about the Obamacare case, though, is that it was the first time the federal government had imposed that kind of a mandate, and it's generally agreed the federal government does not have this police power, and so that's why the case was so hard fought. As it ultimately turned out, the Supreme Court said the mandate is not justifiable under any kind of police power or regulation of commerce or anything like that. That's why the court interpreted it as a tax in order to uphold it, despite the fact that the federal government did not have the authority to do what it did under its other powers.
Well, now, Rob, was that a great case of judicial sleight of hand in some way?
It illustrates the fact that despite the propaganda that you get from the newspapers, we do not have a conservative Supreme Court.
Yeah.
In the case, Justice Roberts is someone who subscribes to what's called the doctrine of judicial restraint, and it's judicial restraint to an extreme. It's judicial restraint to the point where if there is any reasonable way by any interpretation to uphold an otherwise unconstitutional law, you uphold it. Another way of phrasing it is to say a law is not unconstitutional unless it's unconstitutional beyond a reasonable doubt. That particular method of interpretation was first popularized by progressive jurists like Brandeis and Cardozo, and today people who are sometimes billed as conservatives adopt that same philosophy. That is not the philosophy that the founders, I think, expected the court to apply. I think the founders' view was that you interpret the Constitution and the statute fairly, that you don't strain to find a statute constitutional when by any fair interpretation it's not constitutional.
Okay, we're going to take 1 minute time out. Mike is on the line, and we do have a line open at 721-1290 if you like to visit with Rob Natelson. Time is growing short, only about 8 minutes left in the program, so our number is 721-1290. Only a few brief minutes left to visit with Rob Natelson from the Independence Institute in Denver, Colorado. Now, let's get one more caller on. This is Mike. Mike, you're on with Rob. Go ahead.
Oh, hi. Thanks for taking my call. I just joined your program a little bit ago, so if this has already been answered, forgive me. I was wondering about the 4-4 split, about the union dues requirement, and could that have been delayed by Roberts, and can it be revisited, or is it a done deal now?
Well, we haven't answered that question, so good question.
Thanks.
It is a good question. I think it can be revisited. I think unlike a decision where you've got a clear majority of the court, I think it can be revisited. In fact, the Supreme Court has done that sort of thing when they get a full bench after having decided some cases by a short bench. Could Roberts alone have postponed it? Probably not. I'm not familiar if there's a Supreme Court rule on that subject, but my guess as to the decision as to whether to postpone it or decide it probably would have been made by a majority of the justices. So I don't think he could have done that alone, but I think it is ripe for revisiting. Or I don't want to use the word ripe. That's a specific legal term. I think it's a good candidate for revisiting, but it may have to come up from the courts again, a new case.
So I had a question. I kind of teased it during the break, but it is this. We watch the court, and it just seems so divisive and so different. The way that they approach the text seems just, like rival schools, basically. And a lot of people wonder, at least I wonder, maybe the original framers made a mistake, that perhaps they didn't put enough checks and balances in the Constitution when it came to the Supreme Court and the way that it functions. I wanted to see what you thought about that.
This is something I mentioned in my book, The Original Constitution, what it actually said it meant. The founders did not think much of Parliament, and they didn't think much of the king, but they were great admirers of the English judicial system. And one of the hallmarks of the English judicial system was a very high level of professionalism and a very high level of impartiality. And that's, I think, what they expected to get, and they wrote the Constitution with that expectation in mind. I don't think we have that anymore. I think there's been a lot of rot into the judicial system, intellectual rot, that I think has been encouraged by the law schools in particular. And so under the circumstances, it may be one of those situations where we've had changed conditions, and it's time for a constitutional amendment that reins the court in or rewrites how the court decides cases somehow. We don't really have time to explore that now, but that's an example of where changed conditions maybe call for an additional check or balance.
Well, just generally, would you have like a legal SAT quiz they got to take, or what? What kind of procedure could you do to make someone's opinion?
Some people, for example, are suggesting term limits on the Supreme Court, maybe one single long term. So members of the court recognize they've got to go back to the private sector after their term is over and live under whatever they've done. Some people have suggested that we erect over the Supreme Court for constitutional cases only a higher court where the judges are appointed by the states.
A super Supreme Court.
Something like what they have in the Federal Republic of Germany.
Right.
So there are a number of different reforms that have been proposed.
The Supremer Court.
The Supremer Court, yeah. The Germans call theirs the Federal Constitutional Court. It's a very, very high court, and it would get its ultimate appointment from the state. So those are examples of some of the suggestions that have been proposed. There are others as well.
Well, I like that last idea, but boy, would that take a lot of power out of the presidency, it seems.
It would, because the president would still appoint Supreme Court justices with the advice and consent of the Senate, but the very highest court on constitutional cases would consist of justices appointed by the states.
Now, the last time we visited, Justice Scalia had just passed, and we were talking about the possibility of, considering a new justice with the presidential election coming up, one has been named. So does the Senate have any sort of responsibility to do your duty, do your job, get out there and
this is a political determination. I mean, the Senate doesn't have to do anything constitutionally. They don't have a duty to do anything. One could argue that their duty is to stall and to see how the election comes out. I think this particular appointment, from what I gather, is about the best that could be expected from President Obama, and it's probably better than anything a President Clinton would nominate. So my own view is that if Donald Trump is nominated, very unlikely he would be elected. They probably ought to go ahead and confirm him. If, on the other hand, someone with a better possibility of winning the presidency is nominated by the GOP, then they might just want to wait until the next president.
So you would go for Garland if the Republicans
if
go for
Donald Trump
Trump
is nominated, there's virtually no chance he's going to be elected.
Seriously,
and so,
do you really think so?
And so I would go ahead and approve Garland as better than anything is likely to come out of Hillary Clinton presidency.
Wow. So everybody I've talked to at every pundit I've ever seen, both conservative and liberal, tell me that if Donald Trump is nominated, that he will lose in spectacular fashion to Hillary Clinton.
He will lose spectacularly. That's right. That's right. I mean, we've never had a candidate with such high negatives, and so under the
Hillary Clinton has her own negatives.
Yeah, but
the other thing,
not even as high.
But they're not at the level of Trump. The other thing is that Donald Trump is not a conservative. Nobody knows what if he were by some miracle elected. Nobody knows who or what he's going to appoint.
Right.
And so that's going to be another reason for approving Garland.
So he's a loose cannon, basically.
Well, he's not someone whose past inspires confidence. Let's just put it like that.
John is smiling.
I love Rob.
You should see his smile.
Rob, so many times this show has turned into
ear.
John doesn't like Trump, but everybody else that calls in does. So I'm happy to have at least one other person out there.
Look, a presidential election is not the time to throw dice.
Powder River, let
I'm serious, and that's what you're doing in this situation. Yeah. And it's not the time to bring in a lawyer to do your plumbing.
Yeah,
you know.
All right, Rob. How do we get a hold of your book?
Just go to Amazon. It's called The Original Constitution: What It Actually Said and Meant, and it's written for the layperson. It tells you what the Constitution meant right after the adoption of the Bill of Rights, and it's inexpensive.
All right. Always a pleasure, sir. Thank you so much for being with us every month.
Thanks, guys.
All right, take care, Rob.
Bye-bye.
And happy anniversary, sir.
Thank you.
All right, you take care. All right, tomorrow, open phones?
Yeah, open phones.
All right, maybe we can talk more about this Trump guy. Stay with us.